Good morning, everyone. Thank you very much for being here with us today. My name is Monica Murayama. I am an LLM candidate at Georgetown Law, and together with Lucas Passos, we welcome everyone to this first Georgetown Brazilian Arbitration Day. We're proud to organize the first edition of this event in cooperation with the Arbitration Channel, the Georgetown Brazilian Law Association, and the Georgetown International Arbitration Society. We are thankful to all of our panelists, and we're happy that we put together a team of 18 leading arbitrators, professors, and lawyers to discuss the hottest topics and recent arbitration developments in Brazil. So for our keynote speech, I would like to welcome Professor Anne Marie Whitesell. Professor Whitesell is Professor, LLM Program, and Faculty Director of the Program on International Arbitration and Dispute Resolution at Georgetown Law. She has practiced in both the United States and in France, and has acted as arbitrator and counsel in numerous international arbitration cases. She was Secretary General of the ICC International Court of Arbitration, and Professor Whitesell also serves as a member of various boards and committees related to dispute resolution and international arbitration, and is the director of the Alternative Dispute Resolution Center of the International Law Institute. Professor Whitesell, please, the floor is yours.
Thank you very much, Monica. On behalf of Georgetown University Law Center, I want to welcome everyone to this first Georgetown Brazilian Arbitration Day. It is truly a pleasure for me to be introducing this wonderful program that has been organized by the Georgetown International Arbitration Society, the Georgetown Brazilian Law Association, with the kind assistance of Arbitration Channel. Today's program makes me personally particularly happy because Brazil is a country where I have watched the enormous development and advancements that have taken place in international arbitration. I'm old enough to remember Brazil before the New York Convention, when it entered into effect back in 2002. I remember how excited we were in the international arbitration community when Brazil finally entered the New York Convention. And I traveled to Brazil at the time, and I saw the energy and enthusiasm with which the legal community embraced arbitration. And after that, Brazil became, for me, one of the leading examples of how international arbitration can flourish and be effective when there is a desire to make it work. Now, looking at Brazil today, we know that commercial arbitration is the most commonly used and respected method of alternative dispute resolution. And it has experienced a steady growth in the number of cases, especially over recent years. According to the most recent White and Case survey, São Paulo is the only Latin American seat among the 15 most popular arbitration seats in the world. It's the third most preferred seat for arbitrating Latin American disputes. And according to ICC statistics, in 2020, Brazil reached the second place in the world for party nationalities, representing the cases at the ICC with over 150 parties. It also reached the fifth place, looking at the ranking of the most represented nationalities among arbitrators in ICC cases. And finally, Brazil has also been ranked fifth most selected place of arbitration in cases administered by the ICC. But if we look closer to home, Brazil also occupies a very important place here at Georgetown Law. Brazil has been among the top 10 countries in the Georgetown LLM program consistently over recent years. And those Brazilian students, they don't just come from São Paulo and Rio, they come from many other parts of the country. And the number of students from Brazil that are enrolled in our arbitration program has continued to grow. especially in our international arbitration certificate. It has grown exponentially over the past decade, showing that Brazil has a flourishing arbitration community and practitioners that are seeking U.S. training. We have the pleasure of having a program at the law school called the International Arbitration Scholars Program, which is a very competitive program where students do research and writing. And this year, I have the pleasure to be teaching that program with Lucas Passos as one of our international arbitration scholars. Now, we also have the Brazilian Lawyers Association, which was just created very recently, and a very, very strong Brazilian alumni group that allows the Georgetown network to continue once students have left the law school. We are extremely happy to be hosting this first Georgetown Arbitration Day. We hope it will become a tradition in Georgetown law, and we hope that it will continue to strengthen the deep connections that exist between our law school and the Brazilian legal community. You have a very interesting program today that has been developed by Lucas and Monica with the help of everyone in Brazil. And I want to thank all of the speakers that will be participating, the sponsors, and of course, the organizers. I hope you will enjoy this day. I personally am looking forward to learning a great deal. I want to thank again everyone for participating. And now I'm going to turn it back to the organizers. So thank you again and have a wonderful day.
Thank you very much, Professor Whitesell, for your very kind words. It is our honor and pleasure to have you delivering these welcoming remarks. We are very happy to kick off the Brazilian Arbitration Day at Georgetown Law, and we also hope this becomes a tradition for many years to come. Truly hope that the future generation of Brazilian arbitration students at Georgetown keep doing this, and if not, Monica and I will be around to push them. So thank you once again, Professor Whitesell. Now I have the honor of moderating the first panel of the Georgetown Brazilian Arbitration Day. The panel entitled, "Is Brazil a Truly Arbitration-Friendly Jurisdiction? Current Challenges and Next Steps for Brazil to Become a More Popular Seat of Arbitration." The idea for this panel is to not only give an overview of the state of play of arbitration in Brazil, which is going to be very useful for people from other jurisdictions who are watching us today, but also to discuss a little bit of where does Brazil stand in the global arbitration scenario. How is the relationship between Brazilian courts and arbitration? How is Brazil being perceived as a seat of arbitration? How international practitioners see Brazil as an arbitration market? And to answer all of these questions, I have the honor to count with the help of 4 authorities in international arbitration, not only in Brazil, but in many jurisdictions. We have Anne Beneti here. Anne is a partner at Beneti Advocacia. She's a very experienced, both acting as a counsel, as an arbitrator in a wide range of disputes. Anne holds an LLM from the London School of Economics and a PhD from the University of São Paulo. Anna was also a guest researcher at the Max Planck Institute in Hamburg. We also have here Marcelo Ferro. Marcelo is one of the founding partners of Ferro Castro Neves Daltro Gomide, one of the leading boutique arbitration law firms in Brazil. Marcelo has broad experience both acting as counsel and as arbitrator in proceedings throughout the world. Marcelo holds a master's degree from the University of Paris and is also a professor at the Pontifical Catholic University of Rio de Janeiro. We're also happy to have Laura França here with us today. Laura holds an LLM degree from Harvard Law School and is an associate at 3 Crowns LLP here in Washington, D.C. Laura has broad experience in both commercial and investment arbitration proceedings in a variety of jurisdictions. And lastly, we also have José Sánchez here. José is a Colombian practitioner who has been acting as counsel and arbitrator in proceedings handled in English, Spanish, and Portuguese for more than 1 decade. José is a partner of the international arbitration practice at Vincent & Elkins in New York. José is currently one of the ICC IAF representatives for North America. And besides all of that, José is also a Georgetown alumni. So once again, we are very happy to have you all here today, and we really appreciate you making the time to share your knowledge with the Georgetown arbitration community. Well, without further ado, I would like to invite our first panelist, Anne Beneti, to give us the first presentation of the day. Anna is going to present us an overview of the arbitration practice in Brazil. As we know, although Brazil is now a force to be reckoned with in the arbitration scenario, our arbitration history is very recent and not at all uneventful. So Anna, the floor is yours.
Thank you. Thank you, Lucas, and thank you, Monica, for the kind invitation. It's really a pleasure for me to be here speaking to you. I wish I could be in DC right now, but as things go, we can do it from home. I'm gonna I have a slide presentation, and I just hopefully is there. Talk about the state of play or the current situation, how we came to be at this point in arbitration. So I have just an overview, show a little bit of the development in numbers and a bit of the challenges for arbitration in Brazil. Let me just check my time here. So Brazil, as Lucas said, is fairly recent in arbitration. I mean, last 26 or 7 years. And it's the same thing happened to the rest of Latin America. And Latin America was very resistant to arbitration, very excessive trust in local courts, had a lack of trust in arbitration. But okay, the years went by, the need to interact with international community became apparent, and the need to have a dispute resolution method that would also meet this international community. So to say that Brazil was a case of success in arbitration, but also the other countries in Latin America at the same time started picking up pace in terms of meeting the rest of the world in terms of arbitration. We see that the arbitration laws passed around the late 90s and beginning of the 2000s, and pretty much the same in the region. It was a trend that went on. In order to talk about arbitration in Brazil, we had to talk about 3 milestones. They're very, very important. 1996, the law that was enacted. The Supreme Court decision, we had a Supreme Court decision about the constitutionality of the law in 2001. And also, as Anne Marie already said, the New York Convention that was ratified in 2003. I'll talk briefly about them. But before the Brazilian arbitration law, we did have arbitration in Brazil. It was mentioned in some of our constitutions. It was also mentioned in the Commercial Code, 1850. But we had some provisions in the Civil Code, some provisions in the Code of Civil Procedure, but mainly talking about enforcement of the arbitral awards and execution of arbitration commitments. And then that was the problem. Arbitration clause was not immediately enforceable. So you had it in a contract, but you needed to have a commitment to arbitrate when the dispute arose. And the arbitral awards were not immediately enforceable in local courts. You needed to go through a local court recognition and then enforce it. So practitioners thought difficult to use arbitration. They didn't have much of the information, how to do it, how to handle an arbitration case, and also had the problems with enforcement. With the law was was based on the UNCITRAL model law, but not a copy of it. Arbitration with the law is binding, and arbitration is compulsory. And we can take the two arbitrability issues or requirements from Article 1 of the Brazilian arbitration law, those who are capable of entering into contracts, and also matters of property rights. They are also subject to arbitration. There are fewer requirements for enforcement of arbitral awards, and we rely on a territoriality criteria. If the arbitral award is rendered domestically or inside Brazil, it goes directly into enforcement into the courts. If it's considered a foreign award, that means rendered outside Brazil, it has to go through a process of recognition by the Superior Court of Justice. That's the court at the same level as the Supreme Court, but it's a high court that deals with matters of law. And they go through a process, and then they validate this award, and then it can go through an execution. So that's an important issue for us. Talking about the 3 milestones, the Brazilian Supreme Court had to decide a case on the constitutionality of the arbitration law. There was just a matter of if the arbitration clause goes against a waiver, is a waiver of the constitutional right to access of justice. And then at the end, after 5 years of discussion or judgment, the court decided the arbitration is a party's right. So the party can go through an arbitration without being violating a principle of access of justice. It's also access of justice. And then the third milestone, as Anne Marie already mentioned, is the recognition or the ratification of the New York Convention in 2003. I have to say that the requirements for recognition of a foreign award were already provided in the Brazilian legislation. You see in the arbitration law, and also the requirements inside of the courts for recognition. But of course, it is important to have the New York Convention inside Brazil because shows an investment-friendly climate, and also the Brazilian courts and Brazilian courts decisions Brazilian courts can rely on the decisions rendered elsewhere on the New York Convention, and also Brazil can become a part of the decisions about recognition of awards. I've been talking, well, of course, when we talk about the success of Brazil in terms of arbitration and this very fast development, some of the reasons come into our heads. First of all, the number of cases that the Brazilian court system handles is enormous. One judge here at the Court of São Paulo, and we have more than 60 courts here in São Paulo, one judge can handle 6,000 cases. So a very complex case can be taken to arbitration, and the arbitrators will have more time to, or more time to analyze and examine the situation. We also had the Brazilian Arbitration Committee, the CBAr. The CBAR was very much responsible for this engagement of the Brazilian law community into arbitration. They are an academic group, but they also follow up legislation, they follow up courts' decisions, they promote events, and they promote discussion about arbitration. And way in the beginning, they were very, very important, having this mentality going on and promoting arbitration. The Brazilian arbitration institutions are also very important. They are very active, and we'll show later on. And also the support from the courts. I don't want to give any spoilers of Marcelo's presentation later on, but of course, without the support of the courts, we wouldn't have arbitration being as a reliable method in Brazil. Talking about institutions in Brazil, of course, we use ICC, ICDR, LCIA as institutions for administrating arbitrations. But we, from a research we have more than 120 arbitration institutions in the country. Of course, Brazil is pretty big, so we can imagine how many are all over. But the main ones, CAM-CCBC, FIESP, AmCham, the stock exchange here in São Paulo, they are doing a very active job in terms of handling cases and also promoting arbitration. The CAM-CCBC is the first one created in Brazil, and it became a very, very huge case of success in terms of handling cases. We're not talking only about institutions in São Paulo. We have institutions like Camargo in Belo Horizonte, Rio de Janeiro, CBMA, FGV. They are also having a good workload. Anne Marie already mentioned the situation of Brazil in terms of ICC cases. Brazil, if you see, when Brazil had no arbitration law, had fewer cases. In 1997, had only 12 cases with Brazilian parties, and nowadays, like over 100 cases. And Brazil is becoming one of the second in the world in terms of Brazilian parties. I think we are losing for United States right now, but it is huge. It's a clear sign that the ICC is one of important institutions for Brazilian arbitration, and also as a sign that how Brazil is developing in comparison with the world. Also, Brazilian arbitrators. In 2020, we had 88 Brazilian arbitrators handling cases at the ICC. We were 5th place. And Brazil was a seat. We were also 5th place. We are talking about all the cities of Brazil. It's first in Latin America for the ICC. And of course, we're talking about São Paulo and Rio most of the time. São Paulo is with more cases than Rio, but there are some other cities in Brazil also being used as a seat for arbitration. Because of this, the ICC decided to open up an office here in São Paulo. It's the first one in Latin America. And it's doing a quite good job in terms of taking care of the cases with Brazilian parties or Brazilian connection. The ICC, and this is, we only have the numbers for 2020. We're handling 101 cases, disputes over $12 billion. They had 2 emergency arbitrators in 2020. Number of parties is like 147, 136 Brazilian parties with 11 foreign companies. And entity arbitrations, they had 38. I know for sure that already this year, they had 3 emergency arbitrators, arbitrator proceedings. And the cases are picking up this year as well. Those are the numbers from the CAM-CCBC here in São Paulo, and you also can see the level of increase in number of cases, and this is with 2021, and the information is that 418 cases were handled in 2020 as a whole, and 430 already in 2021. So it is one of the biggest centers for arbitration in São Paulo. Most of the cases handled by the CAM-CCBC involve corporate matters. There are over $2 billion US dollars in dispute. Foreign parties are 20%, and 34% of those 20% are from the US. The list of arbitrators involve non-Brazilians, so they have a mix of arbitrators, and they have currently 41 ongoing arbitrations involving public, state, and state-owned enterprises. Also, a concern about gender in arbitration, trying to mix male and female arbitrators. Almost 60% are mixed tribunals, which is an important number. And also they have a duration of 18 months approximately in the proceedings. I also have here, and my slide's not working, here, just to show the FIESP, also the increase during those years. And 2021, 125 arbitration cases handled by the FIESP institution. As I said before, we couldn't have this success or this case of work without the support of the courts. In 2012, we had an interesting event at the Superior Court of Justice, the same level as the Supreme Court, with the justices in order to discuss the New York Convention. And Professor Vandenberg came, and he was very happy to see how the Brazilian community picked up the pace, even though it came later to the, as he called, the arbitration party, was really picking up the pace very, very fast, and how the Brazilian judiciary became an international model in terms of good decisions and decisions handled in support of arbitration. Again, I don't want to give any spoilers, and I'm going to be very brief in this slide, but the CBAr did 2 researches already on cases, judiciary court decisions, and the idea was to see how the courts as a whole, in terms of empirical analysis, saw arbitration, and they were happy to see that the decisions were adequate in most of the cases, very technical by the courts. Those are in cases of nullification actions, or also in recognition for an enforcement of awards. And also there was a good use of arbitration. So there was strengthening the position of arbitration in the country. I can send you also this presentation, but those research are in the CBAR webpage, so you can check it. And a little bit here about the recent changes. Of course, we didn't stop in 1996 in terms of legislation for arbitration, but that's still our main piece of legislation. In 2015, we had an amendment to the arbitration law, and also we had the enactment of a new code of civil procedure, which had some connection whenever you needed the court. So they have some provisions related to arbitration. And it's important to say that these new legislations maintain the normative grounds for arbitration, the principle of the will of the party, independence of arbitration, and independence of the procedure. Everything was maintained. There were some changes, especially in order to make it clear that state-owned companies could go to arbitration, and some delimitation of the activity of the judge before the commencement of arbitration. Those were the important changes. Of course, there were a discussion, but there was veto arbitration for consumer contracts and labor. They're still very highly regulated in Brazil. There are cases that can go to arbitration, but they have to have cannot be the highly regulated cases in those types of disputes. Also, we had, it's important to mention that several of pieces of legislation had included arbitration over the years, like concession law, oil and gas law, transport law, PPP law, in order to try to develop and try to use arbitration for investments in state contracts. So those are the changes that are very, very important as well. And we see from the numbers that the most several arbitration involving state companies are being processed or used or handled in Brazil. There are 2 main projects underway in the Congress. One is a project trying to limit a little bit of the arbitrator's profession, which is not a profession, but a profession, and a worry with the publication of information. So, and a second one is about arbitration for tax issues. The CBAr, as I said, has a group that follows up legislation and also the discussion of this legislation, trying to improve the words and the legislation, try to maintain also arbitration as an independent and a more independent way of the dispute resolution. And to finish, the CBAR also had research last year carried out with the practitioners of arbitration to see how satisfied are Brazilians or the practitioners with arbitration. And the result was quite good. 33% in total very satisfied and 60% fairly satisfied. And then they broke down by arbitrators, lawyers, and internal counsels from companies. And also the result in all three categories was quite good. So it's still a very used method for dispute resolution, especially for the complex cases. Finally, the reasons why parties or practitioners decide for arbitrations, the three main ones were technical decisions, time. A court case can take up to 15 to 20 years to go to all the levels of court in Brazil, so time is very important. And also a choice of arbitrators by the parties at the beginning. I think people want to understand and know who is going to be handling and deciding the case. And just to finish, because this was very into numbers or facts, things that I believe that are the challenges for arbitration in Brazil. Of course, we still are centered in Rio, São Paulo, and some other capitals of Brazil. We have to bring in arbitration to other capitals and cities of Brazil. Develop a larger number of Brazilian arbitrators of knowledge with international commercial arbitration. I think we have to develop a little bit more. Arbitration involving state entities is growing, and I think there is a possibility it's going to be bigger. Maintaining arbitration as an independent method for dispute resolution. This is an ongoing battle we have, I think, everywhere in the world. Arbitration related jurisprudence of arbitration and confidentiality of arbitration is also an ongoing discussion. Diversity and gender, I think there is a worry and a preoccupation by the Brazilian institutions in order to maintain this diversity. And a discussion later on arbitration issue, consumer tax issues, and this is something that is going to be going on for a long time. Well, this is my presentation. Of course, I'm free to respond to any questions and debate with my fellow panelists. And thank you very much again for this invitation. Thank you.
Thank you very much, Anna, for this very insightful presentation. For us Brazilians, it's also nice. It's always nice to remember where we came from and how much we have achieved in such a short time. 20-something years. If you think about it, it's not a long time. And acknowledging how much we did give us hope that we're going to have an even more prolific future for arbitration in Brazil. And also for the non-Brazilian people watching us, I'm sure this was also a very interesting crash course in arbitration in Brazil. So thank you very much. Now we move on to our second panelist, Marcelo Ferro. Marcelo is going to give us some insight on the relationship between Brazilian courts and arbitration. Marcelo, the floor is yours.
Thank you, Lucas. Thank you, Monica, as well, for the kind invitation to participate in this debate. Let me start by saying one very important point to what Anne Beneti has just mentioned in her very comprehensive presentation. I would dare, Anna, to include amongst the challenges something that I keep saying to the Brazilian community as no more lists on arbitral institutions. I invite every practitioner assisting us over here, specifically from the Brazilian community, to create a hashtag no more lists in order to improve that, because I think it's the only point, my fellow colleagues, that put Brazil still in a Jurassic era with respect to arbitration. Because if you have a glance on the international community, there is no one including lists. And I have no vested interest on that, since humbly speaking, I am included in major lists of the major institutions. But I think as acting as a counselor, sometimes this, in order to be narrow to those lists, it's not very good for the parties. And after all, I think it comes to my mind the idea of Jorge Luis Borges, the Argentinian writer, that's saying that you have to be very cautious with the lists, because the only thing that you note on a list are the omissions. So this is important to understand. So I have been asked to address one question and to present an overview of recent decision of Brazilian courts related to arbitration, and specifically pointed out to some controversial ones. And all of this in 15-minute time. It's not exactly an easy task unless you use some technical device such as the double or triple speed on a YouTube platform. But since we do, as a speaker, we do not have this device, let's attack the points that have been addressed to me. First, the question: is Brazil a truly arbitration friendly? Yes, by all means. In spite of an ongoing media campaign led generally by those parties who lost cases, Brazil are trying to attack some arbitrators on a personal basis, I still think that Brazil it's a very friendly environment for arbitration. And the evidence of such amicable environment is coming not only from the legislative side, but also from the judiciary side. As Anne Beneti correctly pointed out, you have seen on her fancy presentation, you have seen the whole Brazilian, the whole movements from the legislative side with respect to laws. But my point is, in the interest of time, my point is to address some evidence that proves that Brazil is an amicable environment for arbitration. And I will address two specific decisions, recent decisions related to arbitration, both of them coming from the Superior Tribunal of Justice. First one is the Special Appeal 1.230431 from São Paulo, just reported Antônio Carlos Ferreira. This is in a dispute related to a registration of an energy contract before the Chamber of Commercialization of Energy. The STJ acknowledged the preliminary competence of the arbitral tribunal to analyze the terms of the arbitral clause included in the contract. And the STJ, in this case, pointed out the negative effect of the competence-competence principle, and therefore avoided any discussion whatsoever related to the disponibility of rights or even the merits of the case. So this case deserves a huge applause from the community. Second case is the Special Appeal 1.903359 from Rio de Janeiro, Justice reported Marco Aurelio Belize. This was decided on May the 11th, 2021. By the way, the first one was decided November 23rd, 2021. And in this second case, it's a very interesting case which reinforces the amicable environment for arbitration. In that case, the losing party of the arbitration filed a motion to set aside the award on the grounds of violation of due process of law, because the arbitral tribunal refused a party's request for further evidence to be produced and based its conclusion, amongst other grounds, on the technical report issued by the expert witness. It's a very interesting award, as I said, because the award pointed out that the expert witness used in arbitrations, unlike the technical assistants hired by the parties, must be impartial and independent from the parties. And this is very important because sometimes we tend to see namely in international cases, the technical assistants acting as hired guns in order to torpedo the other party's arguments, and sometimes having a vested interest in the outcome of the case. So in this case specifically, the STJ pointed out very thoroughly the fact that the expert witness must be independent and impartial. And moreover, the award recognized that the arbitral tribunal is free to seek its conviction from other elements of the files. It's very important because in this case specifically, the losing party has refrained from address further evidence in a certain moment of the arbitral proceedings, and the arbitral tribunal, once deciding the case, decided against that party by shifting the burden of proof to that side, and as a consequence, denying the relief sought. So this party was not happy with that outcome, and just like major Brazilian parties, and it's very sad to say, but it's true, they present a motion to set aside the award based on the violation of due process, because that party specifically has not had been given, according to her version, an opportunity to present the case, which was not true. So let me address some controversial decisions that has been issued in the Brazilian jurisprudence. A first issue I would not tackle, because I believe the panel number 3, which leads to enforceability of international awards, will certainly make a reference with the famous Abengoa case. So this is still making a lot of noise in the Brazilian community, because with all due respect, in my opinion, that was a wrong decision. But let me address 2 specific points on the Brazilian jurisprudence. First one relates to an award issued by the 7th Federal Court of São Paulo on December the 6th, 2021, in a case involving Petrobras. As you certainly are aware of, there are many arbitrations related to Petrobras, and you have to be very aware and cautious by reading those cases, because sometimes, in my personal opinion, the jurisprudence was not completely correct. And I can speak freely because I have no involvement in any one of those cases. So I'm stressing my opinion specifically from the academical background. But this first case, this Federal State Court of São Paulo set aside an award, a partial award rendered by an arbitral tribunal against Petrobras, based on the fact that the controlling shareholder of Petrobras, which is União Federal, was not bound by the arbitral clause foreseen in Petrobras bylaws regarding that specific matter, which, according to that decision, falls apart from the corporate issues, which are the ones that are arbitrable. So I think it's, with all due respect, it's a very narrow reading of the Article 58 of Petrobras bylaws. And before addressing the other controversial decisions, let me say a word about a Brazilian unique device that may affect arbitral proceedings. As my fellow colleagues from Brazil will certainly aware, we have an expression to say when something is typical from Brazil, we say that it tends to be a jabuticaba. A jabuticaba is a very nice fruit that you have here only in Brazil. I personally like it very much, and allow me to say that it gives a very good caipirinha for those who are alcoholic or likes alcohol. But anyhow, this unique device that may affect the arbitral proceedings is known by conflito de competência, which stands for, in English translation, conflict of jurisdiction. The conflict of jurisdiction from the Brazilian side is a device whose use ultimately represents, in practice, in my opinion, the denial of the competence-competence principle, notably in order to prevent the continuity of simultaneous cases in different forums, whether in judicial court or in arbitral proceedings. In a nutshell, what is specifically a conflict of jurisdiction? In fact, my fellow colleagues, conflict jurisdiction is not an appeal, but rather an incidental motion filed in proceedings in which a conflict arises, resulting from a disagreement between adjudicatory bodies and decided by a higher body than the ones in conflict. And this higher body that decide the conflicts of jurisdiction may be the state court or the Superior Tribunal of Justice. A conflict may be filed, a conflict of jurisdiction may be filed when two or more courts assert their own jurisdiction or when both or all courts refuse jurisdiction. The decision that settles the conflict of jurisdiction has a nature of a declaratory relief since it does not change any situation or legal status. Instead, its scope remains to declare which one of the courts involved is the competent one to trial the dispute. And the problem of conflict of jurisdiction, my fellow colleagues, arises with the arbitration, when there is a conflict of jurisdiction between a state court and an arbitral tribunal. The STJ, instead of upholding the competence-competence principle and granting the arbitral tribunal the priority to decide about its own competence, the Superior Tribunal of Justice admits to process and trial the conflict of jurisdiction and decides itself what the competent jurisdiction is, whether the state court or the arbitral court. And this, even in cases in which the arbitrators have already asserted their own jurisdiction. So this, in my opinion, as I mentioned, is a huge denial of competence-competence principle, notwithstanding the fact that if you make a research on the STJ's jurisprudence, you will see that there are many, many cases in which the chambers acknowledge and upholds the competence-competence principle, except when it refers to a conflict of jurisdiction. So with that in mind, for example, I bring to your attention a singular decision granted by Justice Marco Aurelio Bellisi on February 25th, 2022, in a conflict of jurisdiction amongst two arbitral tribunals. It's even weird, the situation, because the parties have acknowledged in these two arbitrations to go to arbitration, but then there is an element of court inserted in the decision because of a conflict of jurisdiction amongst two tribunals. So the single decision granted by Justice Bellisi stall both of the proceedings until the STJ decides the merits of the conflict and appoints which court is the competent one. Last but not least, and in the interest of time, since according to my watch here, Lucas, I still have 1 minute. So let me use this wisely. So I will make reference to the conflict of jurisdiction 151130. Justice Luis Felipe Salomão, as a reporter, decided on November 17, 2019. So in this case, in a motion to challenge jurisdiction filed by the federal government in the context of a class action brought by shareholders against Petrobras, and again, Petrobras, and the federal government as well, these plaintiffs were seeking compensation for the valuation of Petrobras shares in the São Paulo Stock Exchange caused by corruption scandal unveiled by Operation Car Wash. And the decision of this conflict of jurisdiction issued by the STJ has raised several concerns amongst the arbitration community in Brazil, because in some way it reopened these discussions regarding the principle of legality and the need to legal authorization to arbitrate, issues that had been definitely clarified and overcome with the amendment of the Brazilian Arbitration Act in 2015. So in short, that decision of a conflict of jurisdiction accepted the fact that the competent court was the judicial court, and as a consequence, refrained from accepting arbitration against União Federal as a controlling shareholder, because União Federal was the one, again, as a controlling shareholder, which has appointed some former executives of Petrobras that were involved in the car wash scandal. So, in a nutshell, my fellow colleagues, and by requesting my excuses for having overcome in 2 minutes my time, these are the points that I would like to draw your attention to, and I'll be more than happy to answer any questions in case you have. Thank you very much.
Thank you very much, Marcelo, for this very interesting presentation. Yeah, indeed, the past few years have been certainly eventful for arbitration in Brazil. We have witnessed our courts handling all of these landmark cases and producing interesting and sometimes concerning case law. So thank you very much for giving us your impressions on the recent case law in Brazil. You left a lot of food for thought here, and I think it's going to be very interesting to watch where our courts go from here. So now we move on to our third panelist of the day. Laura França is going to address the features of Brazil as a seat of arbitration. Laura is going to address the main pros and cons, and also the areas to be developed for Brazil to become an even more popular seat of arbitration. Laura, the floor is yours.
Thank you so much, Lucas. It's a pleasure to be part of this great event today. Thanks again, Monica and Lucas, for the kind invitation. And it's also a pleasure to be sharing this panel with Brazilian colleagues and international colleagues I've been admiring for so long. So Lucas' initial suggestion to me was that I presented today to you all a case for Brazil as a seat of arbitration. And I must say that that made me very happy, because I know it may sound a little bit cheesy, but Brazil's solid reputation as an arbitration seat, especially in those difficult times we've been going through right now, I think it's something that we all, as part of the Brazilian arbitration community, should be very proud of. And I honestly believe, actually, that there is a great potential for Brazil to become an even more popular seat of arbitration worldwide, and to increase the number of cases we currently have seated in Brazil involving foreign parties. So let me give you some interesting data points that inform this belief of mine. First, there's ample room for increasing the number of Brazilian seated arbitration involving foreign parties. According to a very recent research from CESA, from 2017 to 2018, we've seen an increase of almost 20% in the number of arbitrations seated in Brazil. And that number might sound a huge increase, but actually, if we look at the total number of arbitration proceedings seated in Brazil right now, that number remains quite small. In 2018, only about 8% of the total number of arbitration proceedings seated in Brazil involve foreign parties. So there is still a huge room for improvement in that front. And second, and when we're thinking about the Latin American region in specific, there is, in my view, a suppressed demand amongst Latin American parties to hold their international cases in the region. And I'm not talking here only about commercial cases, but I'm also talking about investment cases. If we look at the Latin American region, the number of investment treaty cases initiated by Latin American investors has grown very expressively in the past 30 years. If we think about the period between the 1990s and year 2010, there was a growth of about 400% in the number of investment treaty arbitrations initiated by Latin American investors. And what is interesting is that most of those cases were filed by Latin American investors against Latin American states. So there is a great potential of intra-region investment cases going on right now. And that increase is also tied to another interesting developing trend among Latin American states and investors, which are now preferring to have sometimes there are international arbitral proceedings seated in the Latin American region, which probably arises from the fact that stakeholders are interested in reducing costs, increasing the participation of regional actors, such as local firms and arbitrators. But it also has to do with the fact that we have seen a strengthening of arbitral institutions in the region and the gradual consolidation of some seats in Latin America as safe seats of arbitration, which is the case, for example, of São Paulo, Rio, Chile, Santiago de Chile, Montevideo, and also Bogotá. What I think is interesting, though, is that because Brazil is not part of the ISTS system, there's sort of a skepticism about whether Brazil is well placed to host those investment cases. And the answer to this question is that we do have a legal framework capable of hosting effectively investment state disputes. In fact, if we compare Brazil to other Latin American jurisdictions, we offer often superior arbitration features. So I think it's up to us, part of the Brazilian arbitration community, to also spread the word and try to get Brazil also a place as a seat in the map of investment disputes. And to make this case for Brazil as a safe seat of arbitration, and especially in cases involving foreign parties, I will analyze 4 main drivers that, according to the Queen Mary and White & Case International Arbitration Survey of 2018, have been considered by arbitration users as the main factors for choosing their arbitration seats. The first of those factors is the general reputation and recognition of the seat, followed by the neutrality and impartiality of the local legal system. The third factor is the national arbitration law of the seat. And finally, users also consider the track record of the jurisdiction in enforcing arbitral agreements and arbitral awards. When we talk about the general reputation and recognition of Brazil as a seat, I'm not going to take too much time here because we've already heard Professor Anne Marie talking about some statistics, and I also kindly and very helpfully mentioned some statistics in her presentation as well. But Brazil has a very solid track record and shares leading positions in arbitration, important arbitration records as an important and popular seat of arbitration. For example, in the most recent Queen Mary and White & Case International Arbitration Survey, São Paulo is the only Latin American seat to appear amongst the 15 most popular seats of arbitration worldwide. It's also the 3rd most popular seat of arbitration amongst practitioners from Latin America, which I think is a data point that is very interesting. São Paulo is only behind Paris and New York in that ranking, and no other Latin American country appears in that list from Queen Mary. I think some factors that help us establishing that solid track record include, as Anna had already analyzed, the high level of engagement of the Brazilian arbitration community, the high level of professionalism of Brazilian arbitration practitioners. We've seen a growing number, for example, of Brazilian practitioners coming to study in the US, as Professor Anne Marie also mentioned. In Europe, getting specializations in arbitration, international practice. Brazil, another point that is very helpful, I think, in establish that strong reputation is the fact that Brazil offers first-class infrastructure for an efficient administration of arbitral proceedings. So we have institutions such as the ICC with offices in São Paulo, CAM-CCBC, CIESP, ANCHAM, CAMARB. All of those have state-of-the-art facilities and well-equipped staff to deal with the needs of the most sophisticated international arbitration users. So after checking this first box, moving to the second box, which is whether Brazil offers a stable, neutral, and impartial local legal system for arbitration users, the answer is also yes. Differently from other countries in the Latin American region, in Brazil, there is no history of political interference in arbitral proceedings. And arbitration has never been seen by the public administration as some sort of threat. In fact, I think Anna also briefly touched on this point, but in the 2015 amendments to our arbitration law, now we have an express provision providing that the public administration can resort to arbitration which is something actually that the Brazilian courts have already consistently enforced way before 2015, but now we have this expressly provided in our law. And the use of arbitration by state entities, and I also gave an overview on that, is also booming in the country, and we don't see a trend of courts being reluctant to enforce awards that decide against state interests, which is something very important to be mindful of course, when you're choosing a seat of arbitration. Users are gonna be very careful about assessing whether the state's interests are implicated in a dispute to define the seat. Because I think sometimes, even though we can have a general perception of a jurisdiction as an arbitration-friendly jurisdiction, courts might not be independent enough to enforce awards against state interests. And that's a reality in several Latin American countries, but fortunately not in Brazil. I can briefly mention, for example, the case of Peru, a jurisdiction that has a very well-drafted arbitration law, but which in recent times has seen some very worrying decisions from its courts and developments arising from the Odebrecht scandals and arbitration relating to those Odebrecht scandals, where several arbitrators acting in those cases have been provisionally detained by Peruvian authorities for allegedly accepting bribes for Odebrecht, simply because they were involved in cases where decisions were issued against state interests. I think another important point in maintaining this neutrality and impartiality of Brazil as a seat of arbitration is the fact that, and I also touched on this point, that the Brazilian arbitration community is very active in lobbying and in doing a pro-arbitration lobby before Congress, and in ensuring that new legislation will not harm and jeopardize in any way the development of arbitration. So that also plays an important role in making sure that new legislation is not gonna have a negative effect in the important developments we had in the past 20 years. So checking those first two boxes, the third box that an arbitration user looks when deciding its seat of arbitration is the national law of the seat, the arbitration law of the seat. And in this case, the Brazilian Arbitration Act is a modern and well-designed law as well. It offers the most important features that an arbitration user needs for proceedings to be conducted efficiently. For example, the principle of competence-competence is expressly recognized. The grounds for annulment of arbitral awards are quite limited and aligned with the New York Convention. There are also, especially after the 2015 amendments of the law, some cutting-edge interim relief provisions. The scope of arbitrable matters is broad. Arbitral awards issued in Brazil have also the same effects on parties than a judgment issued by a Brazilian court, which means that they can be readily enforced in domestic courts if not complied with voluntarily. So that's another very, very helpful and important point for parties in choosing a seat. So it in general provides and guarantees all the necessary features you need to have a predictable legal framework, and it is in line with what foreign parties are looking for when they choose their seat of arbitration. And that's, again, not the reality that we have in the Latin American region. Even in countries where we've seen an increase in number of arbitrations and in the participation of actors in the international arbitration framework, such as, for example, Ecuador, the country until 2021 had courts applying inconsistently its arbitration provisions. And it took the executive a regulation in 2021 in an attempt to guarantee some sort of uniformity in the application of that law. Although until today, we are seeing some weird applications of the standard for the annulment of awards before Ecuadorian courts there is still an unpredictability of the application of the standard by local courts. So I think in the Latin American region, Brazil's modern arbitration law is also something that stands out. The final factor that arbitration users take into account when choosing their seat is whether they're going to be able to ensure the enforcement of arbitration agreements and arbitral awards before local courts. And Marcelo has already analyzed, and I'm not going to take too long here, he already analyzed some recent decisions from Brazilian courts that are both worrying and positive to arbitration. But I think in general, we can say, as Marcelo also, I think, agreed at the beginning of his presentation, that Brazilian courts are generally known for adopting a pro-arbitration approach. Of course, and I think that happens virtually in every jurisdiction, we can occasionally come across some decisions that are outliers and that are going to be subject to some well-deserved critiques, which is the case, for example, of the Abengoa decision. And I think what is important here is that Brazil, differently from other jurisdictions in Latin America, and because of this important engagement of the Brazilian arbitration community, is always carefully monitoring case law developments, quickly reacting when an outlier decision is issued, doing a very good job in effectively trying to reduce the number of those outliers decisions to a minimum. So it is a reality that we are going to have outliers. I think we cannot escape from that, but I think the scenario is overall positive. And some of those positive trends we can identify from previous research, for example, the CBAr research. And we can consistently see, for example, that party autonomy, the principle of competence-competence are usually well respected, enforced by Brazilian courts. In general, Brazilian courts also tend to strictly observe the limited scope of review in annulment requests. And I think that's one of the main and most important indicators of an arbitration-friendly jurisdiction. And recent empirical research in Brazil, and especially if we look at qualitative research, shows that that's a reality still in Brazil. And that's interesting because we've seen established jurisdictions that have had arbitration laws for way longer than Brazil struggling with that. That's the case, for example, of Spain. Until the Brazilian arbitration law, I think that hasn't been mentioned already, but it was also greatly inspired in the Spanish Arbitration Act, which was issued years before the Brazilian Arbitration Act. But until recently, and it was only last year, that the Spanish Constitutional Court issued a decision limiting the reviewing powers of judges in annulment cases. Also, Argentina, a few years ago, another important jurisdiction in Latin America, has seen a Supreme Court decision allowing courts to fully review arbitral awards, including the substance of the decision. That has already been changed in Argentina, but that happened not too long ago as well. So that hasn't been the case in Brazil for a while, which is also very positive. I think another interesting point to mention in comparison to other Latin American countries is that Brazil has specialized courts dealing with arbitration-related litigation. For example, in both states of São Paulo and Rio, we have special chambers dealing with all arbitration-related matters. And that's very useful and effective because it allows judges to become more familiar with arbitration, understand the inner workings of arbitral proceedings, and issue, as a consequence, decisions of a higher quality. So I think all those four factors confirm that Brazil has a strong arbitration framework that in the past 20 years have enabled the country to progressively establish itself as an arbitration-friendly jurisdiction and as one of the preferred arbitration seats worldwide, including by Latin American practitioners. But there is, of course, always room for improvement. I will not take too much time here. I think Jose will analyze this a little bit also in his presentation, but I'll just mention briefly 2 points that I think could help placing Brazil as a leading arbitration seat among Latin American and other foreign parties. So I think the first is the need of a constant improvement and training of Brazilian arbitration practitioners and members of arbitral institutions, we would certainly benefit from investing on, for example, language capabilities if we have this ambition of being a seat of proceedings for other Latin American jurisdictions, which, as we know, are Spanish-speaking jurisdictions. And I think second, I think another very important area of constant improvement, which both Anna and Marcelo already touched upon as well, is the need to continue this constant dialogue between the arbitration community and the judiciary. I think the arbitration is going to be as good as our judiciary in terms of favoring arbitration and enforcing pro-arbitration decisions. I think that was all. I see that I'm already 1 minute over the time limit, so I'll end up here, but I'll be happy also to take any questions and continue the discussion.
Thank you very much, Laura, for your presentation and for kindly sharing with us such encouraging data. As you mentioned, Brazil has been proving that it is a reliable seat of arbitration, especially when you compare the legal framework with our main competitors, especially in the Latin American region. So with all this political instability our neighbors endured over the past decades, all the excessive judicial intervention in arbitration, all these things considered, I do believe we stand out as a very promising and yet sometimes underrated seat of arbitration. So thank you very much for your insights on this topic. We now move on to our last panelist. José Sánchez is going to give his impressions as a foreign practitioner who have been in Brazil in the past on how Brazil stands as a player in the global arbitration scenario. José, the floor is yours.
All right, thank you. Good morning, everyone. Good morning. Lucas and Monica, let me start by thanking you for the kind invitation. It's an honor to be on the first Brazilian Arbitration Day. Years from now, people will talk about us as pioneers, the first panel on the first day, trailblazers. Now, I can only hope to have the eloquence of Marcelo, the level of detail of Anna, and the sophistication and composure of Laura over the next 10 minutes or so that my presentation will last. But I want to give you some background on my presentation before I even show it. I want to give you some background on me so that you can understand where I'm coming from when I give you my assessment of whether Brazil is a truly arbitration-friendly jurisdiction. There's something wrong with I don't know the slide. Okay, I don't think the slide is showing the title correctly. Well, it looks like it did not upload properly, but I'll take a look. If not, I'll just show them. Thank you. Before I start, I want to give you just some background on my own background. I was trained and practiced law in a Latin American country, specifically in Colombia, for a few years, and then I was trained again in New York and have been practicing law in New York and Washington, D.C., mostly international arbitration for the last almost 13, 14 years. So my approach to Brazil comes from the perspective of a Latin American trained arbitrator and practitioner who is also a US-based and trained arbitrator and practitioner. So I hope I can bring that perspective of both the New York lawyer and the Latin American lawyers when I approach Brazil. And I want to go straight to the question that was posed to me on this panel, which was, is Brazil a truly arbitration-friendly jurisdiction? And I think that's one of the easiest questions I've dealt with in my job as an arbitrator, as an international arbitration practitioner for the last few years. It's almost as easy as, do you like the laughter of babies, or do you enjoy a good night of sleep? The answer is absolutely yes, it is. And I believe that the reason we're still asking that question is because there is this anachronistic view of what Brazil is in the international arbitration world. I think that view is actually moot now and has been moot for a significant number of years. So let me start with, let me go back to that point about why Brazil is, in my humble opinion, not only a truly arbitration-friendly jurisdiction, but frankly, a powerhouse, and it's a force to be reckoned with. I will close with that, but let me first go to the importance of Brazil and why we actually even care about Brazil, not only because it's a lovely country and we all enjoy pão de queijo and a good feijoada, and the Brazilian people, of course, but also why Brazil is an important player in the world in terms of its economy, in terms of its arbitration, and how Brazil can improve. And I'll close the loop with my thoughts on why it is, in my opinion, an arbitration-friendly jurisdiction. So I'm not going to spend too much time on the importance of the Brazilian economy, but it's not something that we've touched on too long today. What I do want to say, though, is when you look at the economic data, it should be undisputed that Brazil is where people should be paying attention, should be putting their effort and their energy if you're trying to develop an international arbitration practice that has a focus in Latin America, right? And I know we're not talking here to entrepreneurs in technology industry or other industries. We're talking mostly to an international arbitration community. And to you all interested in developing an international practice in Latin America, I'll tell you, the economic data tells you all, right? There's a reason why people should actually be paying attention to Brazil. Look at the economy. Look at the size of the economy of Brazil. I appreciate that we all have to pay attention to jurisdictions like Chile, Colombia, Peru, but Brazil and Mexico are in another playing field all by themselves, and Brazil more so than Mexico. So you're talking about the 12th largest economy in the world. You're talking about the largest economy in Latin America. You're talking about an economy that keeps getting foreign investment from Asian countries and Asian players, which are the ones that are actually currently investing. You're talking about a lot of investment from Far East and actually from Southeast Asia that you are not seeing in other countries in Latin America, except for, say, Chile. But the size of the economy is so different that this should be the end of my presentation. Do we need to care? Should we care about whether Brazil is an important player in international arbitration? Just look at the data. The answer is clear. There is a reason why when I started practicing international arbitration law, international arbitration in the United States back in 2009 in New York, I decided immediately to also focus on Brazil and learn Portuguese and visit Brazil as much as I could and get on as many Brazil-related cases as I could, because I saw this. I saw the trend and I saw the importance of Brazil. Rudyard Kipling once said of China, "Let China sleep, because when China wakes up, no one will stop it." And I don't want to be quoting myself next to Rudyard Kipling, but the truth is that pay attention to Brazil, because when you open your eyes, it will be just too late, right? If you really want to get serious about having an international arbitration practice that touches on Latin America, this is the place to be. Brazil is the place to be. I'm no luminary, but there's a reason I started focusing on Brazil 10 years ago or so. So if you look at the economic data, it's also important to understand the importance of how elastic the Brazilian economy is, right? You can talk about important companies like Petrobras, and I think it's mentioned in my slide, but the economic data doesn't tell you the full picture, because one thing you also need to understand is how much spending actually there is in Brazil. There's a lot of spending in a number of resources. I think it's one of the 3 economies in terms of household spending in the world. And anyone that goes to Brazil can see that people actually love to spend money, and I mean this with all due respect, that's part of capitalism, and actually finance a lot of things, right? Now, the Brazilians finance even the coffee that Marcelo is now drinking. If you go and get it at a local coffee shop, it could be financed to 24 months. And all that generates a flow of resources and generate a power to the economy that is significant to what we do, to disputes. There is as I said, there is investments from Asia. I don't want to touch too long on this because I'm going to run out of time, but there is significant investment from Asia, from China, mostly from Singapore as well. And with that economic background in mind, then let's see if that powerhouse economy that we've been discussing actually is truly a good place for international arbitration. Is Brazil a significant player in international arbitration? Absolutely, you bet. the solid framework, the legal framework is solid. And I know that I guess sort of the core trinity that you look at when you're analyzing a country, at least from a point of view of an investor in the United States that wants to invest money in another jurisdiction, and they come to you and they say, okay, can we go in that country? From a disputes point of view, is it okay if we go there? The core trinity that you start with would be the UNCITRAL model law, the New York Convention, and then ICSID. We'll talk of those three relatively quickly. In terms of the UNCITRAL model law, we all know that it was slightly amended in 2006. We all know that Brazil, as Laura very clearly explained, actually based this new arbitration act issued in 2015, both in the UNCITRAL arbitration law, but also based on the Spanish Arbitration Act. And I think that's okay. Not many people are coming out to criticize other jurisdictions because they have not issued the UNCITRAL model law as revised in 2006. Some significant jurisdictions have done it. More importantly, Singapore has done it. Some jurisdictions in the US have done it. Florida has done it. Florida has basically enacted the UNCITRAL model law as revised in 2006. But not every jurisdiction in the world has done it, and that's fine. France didn't do it, and no one is saying, well, France is not a friendly arbitration, an arbitration-friendly place because they didn't enact the UNCITRAL model law as revised. No one is saying that about New York either, right? And New York hasn't done it either. So let's start with something that should be basic. Brazil has a solid legal framework for arbitration. The Brazilian Arbitration Act is a solid piece of legislation. It's at the vanguard of the arbitration world. And the criticism that it sometimes receives that, well, it's not based on the UNCITRAL model law, so there is uncertainty, it's actually unfair because no one is saying that about France. No one is saying that about New York, right? So why are we saying it about Brazil? Just because we have this preconception that Brazil was actually a place where bad things happen for arbitration practice. That, in my opinion, is unjustified. Second, in that core trinity of analyzing whether Brazil is an arbitration-friendly jurisdiction from the legal framework point of view, the New York Convention. The New York Convention is a game changer. And I don't need to go into detail on that. We all know why it is in terms of enforcing arbitration agreements and arbitration awards. But the fact that Brazil has enacted the New York Convention or has adhered to the New York Convention, I apologize, it's a huge development that, frankly, we should not even be talking about anymore because it's been over 20 years. And in terms of ICSID, I do appreciate that there is some reluctance in the arbitration community to truly establish Brazil as an arbitration-friendly place because they're not part of ICSID. There are other ways to resolve disputes that are outside of ICSID. I do appreciate, well, at first impression, people say, well, they're not part of ICSID, so don't put your money there. That is a short-sighted view of the world, right? It's a very short-sighted view of the world. It's not, in my opinion, it could be the beginning of the analysis, but it should not be the end of the analysis. No serious investor will tell you that that's enough of a reason to not invest in a country or to actually not go to that country. There are other ways to protect your investment. And I think that's just not, it's unfair criticism that Brazil gets to. That said, it would be nice if they change that. There is yet another area in which Brazil is, in my opinion, again, at the vanguard of international arbitration, which is in terms of public works. Brazil has enacted a significant number of acts, statutes that actually adopt a pro-arbitration approach to public work arbitration. And you don't see that in many countries in the world. The truth is that when you go to Brazil, everything is subject to arbitration. That's an overstatement. But public works are subject to arbitration. And that's not something that you see in many places. Some jurisdictions have now more friendly or more favorable policies to arbitrating disputes related to public works, but it's not as universal as other people would think, as it is in Brazil. So at that point, Brazil is at the vanguard again. And here's an very interesting development. People talk about Brazilian law, forgetting that there is this federal law, which is also pro-arbitration friendly, but there is also state statutes that are very arbitration friendly, also with respect to public works. You don't see that in other countries. I'm not sure that, and I mean this with all due respect and not having conducted a significant analysis of the different states, I'm not sure that a country as important for the arbitration community as, say, Mexico, is actually in the same position. Clearly, all this development could not be, and all this strength of the arbitration in Brazil could not be sustained without a strong number of institutions. I think Anna correctly mentioned that there is over 90 institutions in Brazil. There is over 200 million people in Brazil. You guys need a bunch of institutions to handle so many cases. But it is true that the two most important are the Brazilian Arbitration Chamber of Commerce and the ICC now. And it is true that now Brazil is becoming this arbitration culture where you see all these Brazilian arbitration days, Brazil São Paulo Arbitration Week, the ICC Brazilian Arbitration Day, the Arbitration Congress, and now starting today, the Brazilian Arbitration Day from Georgetown Law. You'll see it in the next time they make this presentation. That will be bullet point number 1. I don't want to go too deeply on data. I think you've heard the data from Professor Whitesell, from Anna, and from Laura. You all heard data how Brazil actually is becoming a powerhouse for disputes. It's actually the favored nationality or the most important nationality when it comes to disputes handled by the ICC. I think I got the wrong slide. I meant this slide. And as you can see, and I think you heard it. You had all those numbers before, so I don't want to dive too deeply on that data. And this is the slide that I meant to show, by the way. The nationality most represented within Latin America, 38%. Second most represented nationality worldwide in arbitration. Second in countries that refer their domestic disputes to arbitration, and within the top 5 most common arbitrator nationalities. I mean, the data again speaks for itself. Hooray, Brazil! Go Brazil! Before I talk about areas for improvement, I do want to mention things that are not on my presentation, but that I also want to share with you that will show you and hopefully cement any conviction that you may have that Brazil is an arbitration-friendly place. First, today you heard different practitioners. I think Marcelo talked about it, and I think Laura talked about it, talk about the issue of competence, and they went by very quickly. And they addressed the issue of competence very quickly, as if it's something that is universally accepted. It is universally accepted among international arbitration practitioners and sophisticated practitioners. But it's something that Brazilians now have that is almost second nature to them, that other jurisdictions have not adopted to that degree of assimilation as you have. To you, competence is an undisputed principle. In most modern legal system, that's the case, but in the culture, it is not. People still struggle to understand that concept, lay people who are not day-to-day practitioners. I think that's actually now embedded in the Brazilian culture, legal culture, to the point that it's not embedded in many legal cultures, say sophisticated countries like New York, jurisdictions like New York and France and England. So that's a huge point that you guys enforce the arbitration, the competence principle as strongly as you do. Something that is not talked about much is how highly differential Brazilian courts are to arbitrators' findings of their own jurisdiction. And when the New York court does that, which by the way they need to do under the Federal Arbitration Act and very well established Second Circuit precedent, we all stand up and clap and say, see, New York is a truly arbitration-friendly jurisdiction. When a Brazilian court does that, it doesn't make the news. But the truth is that Brazilian courts, Brazilian judges are highly differential to the findings of arbitrators with respect to their own jurisdiction. Same as in the FAA, Federal Arbitration Act. It's not a criticism to New York. It's just saying, why don't we put the spotlight in Brazil as much as we're putting it in New York? There are developments that are so positive for the arbitration world that are not even getting attention because we have all these other developments that are big and newsworthy that we're not covering. For example, the Brazilian insolvency law was amended in 2020 and now provides that a company's application for reorganization does not entitle the trustee to leave the arbitration agreements without effect or to effectively make his way out of an arbitration agreement. And that's something that other legal systems share. And that's something that my fellow arbitration practitioners from Brazil can tell me may have happened before. But the truth is that you now have it in a statute in the Brazilian insolvency law, as recently amended, which cements that legal principle and mitigates any concern that that's a way or that's an anti-arbitration mechanism. It's a huge development, in my opinion. I was mentioning that Brazil is at the vanguard of international arbitration issues, and I want to say that Marcelo stole my thunder, because I thought I was going to break the news when I was going to say that on March 17th, the Federal Court of Appeals actually decided an issue of conflict between two arbitral tribunals. And Marcelo said that that's February 25, not March 17. I have no reason to that. You're right on the date, Marcelo. But let me underscore the importance of that decision, because I think although you touched on it, it may have been lost on our audience how big of a decision that is. How often do you see a court anywhere in the world that is actually deciding jurisdictional conflicts between two arbitration tribunals that have said that they both have jurisdiction over the same matter? That would create in other jurisdictions a mess that involves an ICSID injunction, maybe one arbitrator actually preventing the parties from appearing before the other arbitrator, and so on. You now have a Federal Court of Appeals. I know it's a preliminary decision, the way I understand it, but you now have a Federal Court of Appeals saying, under the express terms of the Constitution, I have the right to decide conflicts of jurisdiction between tribunals, and that includes arbitral tribunals. I think that's a huge step forward in the competence-competence process, or in the jurisdiction process, I would say, in the analysis of jurisdiction process. And the reason it's important is because that kind of decision will give more clarity to the arbitration community. I could mention other advantages of Brazil as an arbitration-friendly place, like how favorable they are or how friendly they are to interim measures both under the text of the statute, and also how they allow those interim measures issued in arbitration to be enforced in local courts. Something again that is now should be commonplace in leading arbitration jurisdictions in light of Article 17 as revised of the model law. But that's also the case in Brazil, even though they didn't adopt the model law. But I would close my remarks with Brazil being an arbitration-friendly place before I talk briefly about things or areas where Brazil should improve or could improve. And I say that with all due respect. But if you're going to compare Brazil to, I think if you're going to compare Brazil to other Latin American jurisdictions, my humble opinion is you're wrong. I think Brazil is now ready to go toe-to-toe with leading jurisdictions in the world, say New York, France, and England. I don't think you should be pigeonholing Brazil to Latin American disputes. But if you are, you need to look no further than what happened in Peru, as Laura was saying, when Mr. Canto Arias and other arbitrators were put in jail for their participation in an arbitration proceeding, unfortunately, and provisionally, because my understanding is that they were released quickly thereafter. You need to look no further than what could happen in Mexico with so many amparos being filed against your arbitral decisions. And unfortunately, Colombia is not exempt from that with their tutelas, which is their other name for amparos. And it's an issue that those countries need to resolve, and are issues that are not, I don't want to say are non-existent, because every country has its own problems, but are not as prevalent, nearly as prevalent in Latin America. So what I'm trying to say here is Brazil is by far your best choice in Latin America, but you should not think of Brazil as only Latin America. You should think of Brazil as a leading jurisdiction in the world. There is no reason why Singapore should be a preferred seat 20 years from now, especially for this hemisphere, in my humble opinion. Now, areas for improvement, because as much as I love Brazil, with all due respect, I'll say there are things that we can improve. ICSID is one of those. I understand that there are reasons not to be ICSID, but it's been mentioned. Two things that are not here and are important to mention. One is, unfortunately, the threat of corruption looms large, and arbitration is only as strong as the institutions that apply or that participate in the arbitration process. I don't think that there is spread suspicion of corruption among arbitrators in Brazil. Thankfully, that's not the case. I think at least the people I know and my perception of Brazilian arbitration is that it's clean. There's no widespread corruption, but I'm not sure that foreign investors think highly of Brazilian courts when it comes to being concerned that they may be subject to corruption. And unfortunately, until a country does not truly address and root out the corruption will bleed into the judiciary, and that corruption in the judiciary may impact the opinion of arbitration in a specific country. And I say that with all due respect to my Brazilian audience, because I do love that country, and I hope that that problem continues to be improved upon and solved. And one issue that I'm confident that, because I'm talking to leading voices in the arbitration community in Brazil, could be further considered is, in my opinion, Brazil is missing a mechanism, and if it exists, I apologize, I missed it. But it's missing a mechanism like the one that countries that have adopted the revised UNCITRAL model law now have in Article 2A. Article 2A of the revised model law of UNCITRAL is basically based on the Vienna Convention and other UNCITRAL model laws that have adopted a similar article, which says when you interpret this law, you should think of it as an international piece of legislation, and you should keep in mind its international origin and its international goals. And what that has done for countries that have adopted that article is that it has forced the interpreter of the Arbitration Act that adopted the UNCITRAL law to also look at decisions from other countries, to look for uniformity when you're interpreting a specific piece of or specific article of your arbitration law. So, for example, a judge in New Zealand will actually, which has adopted the model law as revised in 2006, will actually consider, I'm not saying it's binding, but he will consider decisions by Hong Kong also interpreting the model law, because the model law has also been adopted by Hong Kong. So what we do when we have that kind of article is that we invite our judges, our practitioners, to also look for decisions from other jurisdictions, so that when you apply a specific article in your Arbitration Act, you're giving it an international interpretation. And you're keeping in mind the idea that we all have to have not only uniform legislation, but also uniform legal framework, meaning let's not only draft something that is similar, let's apply it in similar ways. My humble opinion is that Brazil is missing an article like that, with the force that Article 2A brings to the model law as revised in 2006. And finally, the issue of diversity. I would be remiss if I don't mention diversity. Let me start by saying again that Brazil is at the vanguard of diversity when it comes to, in my opinion, because I compare it to other countries, race and minorities. If you just when you go to Brazil, you realize that it's not the issue that it is in other jurisdictions. I will not name names because I don't want to offend anyone. But in that sense, Brazil, in my opinion, is actually a very positive country overall. But the issue of diversity in terms of female appointments in arbitrations remains something that needs to be improved. I'm showing here some statistics that show that, for example, for CAM, the female arbitrations, I actually should say female arbitrators, went from 12 to almost 30% in 2019 compared to 2014, but it's still not a full parity. And as you can see from the statistics I have up there from the LCIA and ICSID and others, there is still room for improvement. There is a trend, positive trend, right? We're going from 8.5 to 11 to 12 to 12 to almost 14, but there is significant room for improvement. So with that, I hope I have covered the issues. I hope we're now trending with the hashtag NoMoreLists, as Marcelo requested. And thank you, Lucas and Monica, once again for having me.
Thank you very much, Jose, for such interesting remarks. It is always good to hear the perspectives of foreign practitioners about our arbitration practice. It is very easy for us to forget how big of an economic player we are and how also this immediately reflects in our arbitration practice. So thank you very much for sharing with us such interesting data and impressions. Unfortunately, we are running out of time, but I think we can take one question from the audience. And we have one here about double hatting and repeated appointments, which is something that is being discussed a lot recently, especially in the investment arbitration context. So it would be nice to hear a word about that in the commercial arbitration context. So if any of the panelists could take this one, and then very briefly, and then we move on to any final remarks you may have. Marcelo?
So thank you, Lucas. I'm happy to take the lead on that. And I'm speaking under the control of my fellow colleagues here in the panel from Brazil and also from the audience. But I think in Brazil, this is becoming a huge problem only after the award is issued. It's amazing how the parties create issues related to double heading and several appointments, multiple appointments, whether by the same party or by the same law firm, and they only do this kind of research after they lose the case. So this is something that I'm not saying that the problem does not exist here in Brazil, because as Jose correctly pointed out, it's a huge economy, it's a huge player. We have seen the figures, but bear in mind that the Brazilian community related to arbitration is not as big as you think. Take, for example, some questions related to oil and gas. The Brazilian community with respect to oil and gas is very narrow. In order to arbitrate a case in Portuguese and in Brazil, there's not going to be a lot of players involved in that field of law. Of course, if you go to M&A, it's a broader environment. If you go to construction, it's even broader. But you have to think about the double hatting with respect not only to the possibility of an arbitrator served as a lawyer and vice versa, because he or she would certainly have the capabilities that the parties need for that specific industry. And again, I invite the future researchers to see and to dig in these cases specifically, just to see how huge are the attacks against the arbitrators once the award is issued. It's very rare, I would say, that an arbitrator will resist if he or she is challenged at the outset of the case. Normally, if it's not a fragile challenge, he or she would certainly step out of the case, because in order not to jeopardize the proceedings. But in big cases, you can rest assured that from a Brazilian perspective, Jose, any big case will lead to a motion to set aside the award. It's as certain as the tax, as certain as the death. You can have a set aside motion after a big case.
Marcelo,
So,
can I defend Brazil from my caro Marcelo?
Sure.
Look, repeated appointment is not an issue exclusive to the Brazilian community. We're trying to fix that in New York. They're trying to fix that. We're trying to fix that in, actually not just New York, all over the US, but mostly New York. We're trying to fix that in the leading institutions, or through the leading institutions in different jurisdictions. When you look at the number of practitioners in Brazil, I know we have the top practitioners in Brazil, and then we have a ton more practitioners. But when you look at the number of good, solid, good legal minds in Brazil that do international arbitration is significantly larger, significantly bigger than what you'll have in other pools in Latin America countries. And the sophistication of the legal practitioners in Brazil is actually amazing, because it's superior, in my opinion, on average, right? I'm not talking one specific person is smarter than anyone. Let's assume we're all the same average smart, but the sophistication in terms of the international arbitration practice is more widespread in Brazil than it is in other jurisdictions. So I think people from Brazil tend to think of Brazil as, oh, well, we only have a couple or a bunch of practitioners. You actually have a lot more than you think you do, but most jurisdictions think that they only have a couple or a bunch, and they're all trying to spread that. They're all trying to open up the game to new practitioners and more practitioners. It's not a problem only of Brazil. It's happening in New York, which I think is actually a leading jurisdiction in arbitration. And setting aside awards based on alleged conflicts, it's something that is also done routinely in leading jurisdictions. I don't want to use the word frivolous, but also on cases where you know that the challenge is not gonna succeed. It's not exclusive to Brazil. I will invite the audience to go no further to look at the last 6 months, a decision issued by a district court in Florida, where it actually refused to set aside an award in a case against against a Latin American, the authority of a Latin American country, because the challenge was basically groundless. So it's not something, and this was in Florida, and this was a major arbitration. I don't want to say more because I could get in trouble, but the decision is public. But it will tell you, it will show you how groundless actually those challenges can be. So it's not only a problem of Brazil, it's actually a widespread problem that we have to fix somehow in the arbitration community. I apologize, I interrupted, Caro Marcelo.
No, very, very, very good observations, Jose. I'm fully aware that this is not a jabuticaba problem from Brazil, since we have been talking about this on the private chat. But anyhow, the situation is that in Brazil, you still have this community that we are trying to improve the participation of young arbitrators. Of course, also as and you yourself, Jose, you correctly pointed out that the diversity is a major issue nowadays here. But the fact is that my only observation with respect to the double hatting situation is not when it occurs at the outset of the case. It is when it is used as a grounds for setting aside the award, because at the end of the day, the minor contact between an arbitrator and with a specific member of the other party, whether the other attorneys, it creates a fuss, a huge turmoil, not to mention also to use the press in order to have their support, and as a consequence having a kind of trial by media. So at the end of the day, my major concern is that this is a problem that major jurisdictions face out. The real difference is how to deal with the problem. And I think it's time in Brazil, and I end here, for three things. No more lists, first. Second, sorry to insist this, but second, start challenging legal experts, because this is not a Brazilian practice. We see this in an international side, but not in Brazil. And last but not least, improve the questionnaire to arbitrators, and also be bold to ask questions from the outset, because normally the Brazilian institutions, they just have general questions related to the arbitrator's perspective, or the potential arbitrator's availability for the next period of time. And I think it's time for the parties to tackle this issue and address more thorough, direct, and important questions on that.
Lucas, I also have a brief comment on this if we still have time.
Sure.
So just very briefly, I think Jose and Marcelo already gave a very good overview on repeat appointments and double headings, but I just wanted to share some results of a research that I conducted with colleagues from Brazil, Naima Milani and Bruno Guandalini, a few years ago. And we analyzed the challenges to arbitrators in Brazil, and also the criteria that Brazilian practitioners use when selecting arbitrators. And I think first, the good news for Marcelo is that the lists are not really one of the preferred criteria of Brazilian practitioners. I think the main one is previous arbitration experience and having seen the arbitrator acting in real cases. And the other thing is that when we analyze the reason for challenges of arbitrators, the two main reasons we received, the two main responses we got from practitioners were that they file challenges precisely in situations of double heading and repeat appointments. And I agree with everything that has been said, especially with José's comment, but that doesn't mean that Brazil has a strong reality of double heading and repeat appointments. In the research, we haven't compared Brazil to other jurisdictions, so I cannot say from a quantitative perspective whether in Brazil we have more of those situations than in other jurisdictions. But I think it also has to do with a reality that is changing very fast in the country. I think in comparison to other countries, we have a relatively short life of arbitration of about 20 years or so. So that's changing a lot very quickly. The pool of arbitrators is increasing, but of course, when you have a community that values very, very strongly the previous arbitration of arbitrators in making appointments, that's naturally gonna happen to some extent. But I don't see that necessarily as a problem as well.
Lucas, can I just very, very brief, because I know we are running out of time. I think the situation can change or it can be handled with two things. First of all, is a better knowledge of the practitioners for this process of challenging arbitrators, because the institutions, they do have rules for that. They don't need anything else. The rules are there and the times to do it and everything is there. And also, I think what Marcelo said out loud, I'm not sure, about how to better develop the questionnaire. Because if people are worried about the number of cases an arbitrator has or the number of contacts they have, this is easily handled by a good questionnaire. And that's if the party decides that that arbitrator with hundreds of cases is the one for that case, even though its workload is quite high, that's the party's choice. So that's not a problem of the system.
I think Marcelo has something to say. Marcelo, but you're muted.
Sorry, just to quote Anna on this by saying that the questionnaire, the party is not a passive party to the questionnaire, but rather an active member. There's not only from the potential arbitrator side the duty to inform, but also from the lawyer's side and the party side the duty to be informed and the duty to dig the same research that has been performed after a detrimental award should have been performed before that. So this is my point.
Well, thank you very much for the very interesting remarks. Well, unfortunately, we just ran out of time, so we need to move on to our next panel, which is going to address the impressions international arbitrators have about the Brazilian arbitration practice. We're very happy to count with Professor Marcelo Huck, Maria Cláudia Prokopiak, José Gabriel Assis de Almeida, and Mauricio Gon for this next one. So please stay tuned. Once again, thank you very much, Ana, Laura, Marcelo, and José. It is our absolute pleasure and honor to kick off this first Brazilian Arbitration Day with your presentations. I'm sure the Georgetown arbitration community really appreciated you sharing your knowledge with us. So thank you very much.
Thank you.
Thank you. Imagine. Thank you.